Gerald Davidson, Bimbo Davidson, and Martin, practice in Iredell and Alexander County and surrounding counties. This is my second term on the North Carolina State Bar Council.
All right. And I don't think Michael Lovejoy's here, so I think that's the only one we don't have. Um, of course, we have Brian and Peter here too. They're going to kind of take this over and give y'all some background on this, answer Judge Hennett's question a little bit about where, how this started, where it come from, where we're going. So at this point, I'll kick it over to Brian and or Peter, whoever wishes to
Yeah,
start.
well, let me first also introduce Dottie Miani is on the call. You may see her; she's got her camera off. But Dottie is Dottie. Oh, Dottie, you just unmuted. You want to introduce yourself, Dottie?
Yeah, I'm Dottie Miani, and I am the registrar for the student practice program and have been doing it for 40 years.
Well,
Yeah,
welcome.
so Dottie has seen it all, and she interacts with the law schools, the supervising attorneys, the law students, and all of that. And so I asked her to join us as well because she's the one that actually does the stuff. So she'll have some insight on how these things need to operate and any sort of tweaks as we discuss rules in terms of practical implementation. So that said, Peter, do you want to start us off here?
So I want to give a little background on where this came from and the status of the legislative side of this, and then also at some point talk about what other states are doing in this area. So this was an idea brought to us by Justice Berger of the Supreme Court and discussions with the chief as well. It was also, we've heard, and Dottie can probably confirm, we've heard from a number of DA's offices over the years of situations where a DA's office, for instance, hires a law school graduate. Maybe it's somebody who was a student in student practice with them. Wants to hire them out of law school, they sign on, then ultimately fail the first attempt at the bar exam. And that puts the DA's office in a place of difficulty because that person can no longer do any sort of supervised practice, and they are either can't retain them or can't use them to fill the needs that they need, and they're back to the drawing board trying to find people. In some places, it's harder than others to find people and hire people in public defenders' offices and DA's offices. And the thought coming from Justice Berger was this is a way to help those DA's offices that are struggling with finding individuals, but also to give those graduates the chance to continue in a supervised role while they study or prepare for the next bar exam, in the same way that we allow the law students to have that supervised practice, potentially, not any additional risk there because they've graduated from the law school and they have a supervised structure in place to watch their actions. Matt Smith and I met with Justice Berger. We talked this out and determined that this would need to be, both a rule amendments from the state bar side and a legislative amendment to Chapter 84-7.1, which is the statute that creates the exceptions on the prohibition of practicing law without a law license. That statute currently says, law students permitted by the state bar, and the legislation that we're working on would add a section that just says a law school graduate permitted by the state bar. And I can share that language with you guys. So when we get to that point, that what we are doing on the side legislatively is, we're working to get this bill passed, get this language changed, just in case we are, for when we are able, or this committee decides and determines, recommends that we go this route and have rules in place, that this could all be in place potentially to cover anyone after the July bar exam of this year. I am working with the Conference of DAs to get this language changed. It is in the bill, a bill that was filed this week, and the language looks like this. Make sure that we can see all that. So it's really straightforward. It's in Senate Bill 429. You can, I'll share this document with everyone so you can have these hyperlinks. But it just essentially says any law school graduate permitted by the state bar to act as a legal intern for federal, state, local government agency, or for a nonprofit corporation qualified to render legal services. That those would be the legal aid entities. So this is limited to this statute would be limited to the government positions or legal aid positions, not the private practice route. And this has been introduced in the Senate in a bill sponsored by Senator Britt and Senator Daniel, and it is part of a much larger bill that is worked on by the Conference of DAs. So we're just kind of snuck somewhere in the middle of it. I didn't choose this title for this section in the bill. I wish that it didn't say that. I think that's a little broad title than what we were actually doing in the statute, but that was what bill drafting, I guess, put in there when they added that to the bill. So that's the legislative side. I don't anticipate there being, I don't know when it'll move and what the support is for this particular section, although I haven't heard any opposition to it, and I know that the Conference of DAs is supporting it. Brian, I can talk about what is going on in other states now, or we can talk about in general the law student certification.
Yeah, just maybe just as like really brief background, if you want to get into some of the other states, the bottom line is that we would not be the first to do this, right?
That's right. And there's different levels of what states are doing. There are some states like Arizona and Oregon that are going a path, essentially taking this as a pathway to licensure, to where law school graduates, instead of going the bar exam route, could undertake a certain number of hours of supervised practice and submit a portfolio of work to get licensure after a period of time. And then there are other states that are more like what we are proposing and have discussed, which was a limited supervised practice for law school graduates. And so on this sheet too, you have Washington, Minnesota, and Nevada are similar ideas to what we are looking at. Washington has an 18-month window. Minnesota's 2 years, and Nevada is a year. And Nevada has limitations on where that law student supervised practice can take place. And so the rule that we'd sent out for you to look at, which is still in draft form, models a few of these states' ideas where you have a time limited situation, limited scope, and clear supervision of that law school graduate. But so that's that. We wouldn't be the first. We certainly are not the last. And we're not going as far as some states in terms of creating a true pathway to licensure. And through this would just be that extension of the idea of that law student practice.
Right. So I guess maybe the first question that we wanted to ask y'all to consider is, you've heard kind of the general idea, the origin, maybe the issue to be addressed. And want to confirm, we talked about it in the issues committee about whether this was a good idea, something that's worthy of pursuing. And I think the issues committee determined that it was worthy of pursuing. So, but want to have an opportunity here to discuss that. I don't know if there's anybody that has any hesitation with this proposal, or if this is something that it's just a matter of, kind of the devil's in the details. Let's just make sure we get the idea is good. Let's make sure we get the rule right.
Yeah, well, that's kind of how I see it. Is I think it's a great idea. I know here in Rowan County, Brandy Cook has run into this issue in some respects. in trying to hire someone and figuring out whether, you know, they've passed the bar, haven't passed the bar, you know, the hurry up and wait game. So I personally think it's a good idea, but I mean, if anybody has any other strong opinions, we can hash it out.
One other thing I would add, it adds to the legal oasis situation, because I know of at least 2 times up here it's happened that local kid was wanting to work for DA's office, but couldn't pass the bar on the first run, couldn't hold the spot for another 6 months. So I think it helps long term on that as well. Hopefully help fix that issue.
Well, I agree with both Greg and Matt. I think this is laudable. I think it's important in terms of maintaining relationships. Obviously, in many cases, somebody has accepted a position, then they find out they weren't successful in passing the bar. And rather than kind of have them tossed out on the street to try to find another opportunity, it seems to me that this is a great way to kind of keep them engaged and allow them another opportunity to pass the bar while they're kind of semi-practicing law, if you will.
I agree, and I would add to it that I like the fact that it gives the person a period of time to pass the bar, because when that letter comes, having received the letter that says, "We're sorry to inform you," it takes a minute to, at least it took me a minute to pick myself back up, because I had never failed at anything. And I say that as a 3rd generation college graduate, skipped a grade, graduated from high school at 16, graduated from college at 20. And when that letter came, the wind was sucked out of my sails, I'm telling you. So it takes a minute to get back up and running. So I think it's laudable and well merited and long overdue.
If I can say, I think it's a great idea. For me, the law firm that I was working with, they were, you know, they were, I was fortunate enough for them to keep me on for a year while I was still trying to, you know, pass the bar. And just like Judge Hennon said, I mean, you know, I felt like if when I got that letter, I felt like my JD meant just another degree because I hadn't passed the bar. And so at the end of the day, it gave me the opportunity to continue practicing. And I think it'll help the DA's office, at least, you know, really for the benefit of the students, so that they could have something to look forward to and that their world just doesn't end with that letter.
Now, I spent time in the public defender's office. Is that a possibility under this?
Yes, it
Yeah,
would.
yeah.
Okay,
Any government,
that's
any
perfect.
government agency or.
Yeah, that's what I thought. Okay, that's perfect.
And the reason we did not add private sector, it gets a little bit too burdensome on the bar, and maybe down the road we look at that, but right now this makes more
No.
sense.
Government is fine, as I alluded to earlier. The way that it's set forth is
Yeah.
is
All right.
good.
Let's get into the rules and see if we can make them work.
But Jay, did you have something to say real quick? I saw you unmuted.
No, Matt answered my question.
Okay.
So I was wondering why I couldn't hire a graduate. So it's
Yeah, and I think the other reason for that, Jay, was generally DA's like government agent offices and legal aid offices have built-in structure that we know because of the way they're designed. Whereas if you open up to private practice, there might be firms that have a very good structure, but there might be some that are very scattered out there and they don't have a lot of people to be able to be there to keep an eye on things or see how things are going. Whereas in these other kind of more official offices, you have that built-in structure and experience with that, supervision of law students as well, which we think, should translate well to this law school graduate idea.
that makes
Yeah,
sense.
we can go ahead. It sounds like everybody's in agreement with you want. We can go ahead and just jump right into what the proposal would be.
Okay, so I'm going to share my screen here. You all were sent these are part of the agenda, but just kind of want to go over just the current state of the rules for law students very briefly, but then explain kind of what we did. Peter and I took a look at this stuff, and this is one of those things that we spent a number of hours just kind of looking at and coming back and talking, and you feel like you can always tweak it and all that, but we think this is in decent shape to at least start the conversation. So currently, law students can be certified to provide this supervised limited practice. And you can do it in a variety of contexts, primarily through a government agency, through a legal services organization that's defined by statute. We're talking legal aid, PISGA, things of that nature, as well as offering the opportunity for students to do this limited practice with a private firm on a pro bono project. And I think another component of the of kind of what we're talking about here when we're just talking about private firms, the proposal here is that law school graduates could be certified in the first two of those categories that I mentioned, government agencies or legal service organizations, not the private sector. And I think, there's also to consider just the nature when we're talking about excluding private sector for law school graduates, just the nature of those pro bono projects with students. They're very limited. It's usually one case and it's very temporary. And if you have a continuous presence like a law school graduate who is now a part of a firm for a year and is basically able to practice law, it could cause confusion for clients. It kind of brings up all those questions, the messy questions of who gets to go on what letterhead and all that kind of stuff. And so we just simply have not included that because we're talking about a law school graduate that might be with a single firm, a single office for as much as a year and 3 months after graduation. So it's the proposal here is to expand the rules, the existing rules. Before I get into the details, I'll say that we looked at simply adding one additional section that addressed law school graduates, but it just didn't work cleanly to have this separate section that was trying to refer back to the student things, because there's some overlap. There's a fair amount of overlap, particularly when it comes to, what does a supervising attorney have to do? But it became kind of messy trying to refer back to rules drafted for students and try to apply just certain parts to graduates. So that's why we kind of took this approach that we're going to go over here. So, the very first section purpose is pretty straightforward. We just we're adding law school graduates, certified law school graduates. You'll see a lot of that in these different rules where we're just trying to kind of add in. It's not just law students, but now law school graduates. So the first kind of substantive thing we did was, to define a certified law school graduate, saying that a law school graduate who's certified to work in conjunction with a supervising attorney to provide legal services through a government agency or legal services organization under the provisions of this subchapter. That models the language in the statute or the proposed amendment to the statute. So we wanted to just kind of have it very clear where this authority is coming from. When we get into eligibility, this is where we kind of split things out. A student has eligibility sort of requirements, and these were amended. Gosh, Peter, what was that? Was that 2019? I think.
It was 2019.
Okay. Yes.
Yeah.
So yeah, the last time that these things were amended, we didn't want to really touch that stuff necessarily. So we just added this new provision for law school graduates. To say, well, what does somebody have to do to be eligible as a law school graduate to get this certification? First thing is obtaining a Juris Doctor from a law school that's approved by the State Bar Council, and that's going to be any ABA approved law school. Of course, there's that stock language that if they're going to be eligible, they have to be introduced by an attorney that's admitted in this jurisdiction to allow them to actually provide some sort of services before that tribunal. And that's just kind of what we do for students. So I feel like it's the appropriate thing here for graduates. We included this section. This is the first highlighted section. And I'm going to come back to this after I go through all these. But this particular section is that the person has to have obtained a passing score on the MPRE. That's that ethics exam that you have to take before actually being admitted to the bar. Or we have this alternative of, do you have to satisfy all requirements for admission to practice law with the exception of bar passage? That's something we need to talk to you all about. Of course, provision 4 is similar to what we have in the student section where, the person who's being certified can be paid. They can't necessarily kind of solicit, like go after, get this certification, and then keep on going and trying to get paid for it. But if they are with a supervising attorney, if they are with an office and that office says, hey, we would like to pay you for your time, then that's permissible. So you can receive it, but the idea here was that the certified law students couldn't really pursue, I guess once they can't go out and solicit, particularly using that certification to solicit employment and solicit some sort of financial contribution there. But they can still receive money. They can be paid if it's offered to them. And then, of course, a test in writing that the graduate has read the rules of professional conduct, and just like all students have to attest as well. So that's the general requirements for eligibility. They mirror largely the student ones that are already in existence. It's just that we're saying obtain a Juris Doctor from a law school, and then obtain a passing score or some other criteria. And I'll tell you, kind of just jumping into some of these other things. One of the things that we did not include: students have to be certified by a representative of the law school that the person has good characters and good standing at the law school. Now that this person has graduated, that did not seem relevant, so we didn't include it. If somebody's obtaining this certification, say 4 months after graduation, maybe after they have taken but been unsuccessful in the bar exam, it might be 5 or 6 months after graduation. And it just didn't seem relevant to ask the law school to attest to the person's character if they haven't seen the person in 6 months. So we eliminated that.
Brian, if I may interrupt too,
Yeah.
the law school folks have also expressed, once they graduate, they want a clean cut with these students, so to speak, with
Yep.
regard to supervision, so they don't get brought back in. So that's another reason it's not in there.
Right. So that's one change. And then the other was this kind of question of, well, what exactly, and I think Judge Hennon, you were kind of alluding to this in some of your prior comments, what do we need to see from these folks to actually be certified, to offer legal services? We kind of played around with the idea of, do we want them to satisfy character and fitness, or pass that aspect of the bar application? Do they need to show this passing score on the MPRE? Do they need to have a pending application to the North Carolina State Bar? We ultimately kind of came up with this language that we want to discuss, and kind of feel like at the very least it should be obtaining this successful score on the MPRE. Just because it's, you might have somebody who decides, I don't want to take the July bar exam after I graduate. And instead, I'm going to take the February bar exam, but I want to get some practical experience until I do that. So it doesn't seem appropriate to say they have to have a pending application, and that means that they wouldn't have character and fitness scenarios too. We can still ask in the application process if the person has been subject to any sort of character and fitness review or something like that. But as far as making it a requirement, I think that would present more difficulties.
And I'll just add that one option is what Nevada does, which is treats it as a negative, just to say that the person has not failed a character and fitness review. So not necessarily that they have passed, but that there hasn't been one that they failed, because that would certainly raise some questions. So we could put something in there to say, if there has been one and they failed, then that could bar their eligibility.
That seems more reasonable. And is it 3 attempts or 3 years?
So that's we go into duration, and that's going to be basically the third bar exam. That this is something that we did actually change for both students and law school graduates. Let me get to that in just a second, because I want to write down here what we're thinking of. So it looks like we'll call this the subs revision. And we'll just say that the applicant has not failed a character and fitness review, something like that. I'll look at that specific language from Nevada. Yeah. Maybe just that, but I think that might be the solution. Okay. Do you all think that the person should obtain a passing score on the MPRE, or is that kind of you probably already have if you're looking to actually apply. But there are some folks who just don't take the MPRE until after they pass the bar exam. It's a relative few from what I understand, but it does happen. Or is it enough to simply say, I can attest as an applicant, I have read the rules of professional conduct. That's what we require of students. We don't require students to pass the MPRE. So what do you all think of that?
Well, I'm kind of leaning towards not requiring it, but yeah, I don't know. I'm kind of torn on that. Give me anybody else have a thought while I run this through my head?
Well, I think it does set a bar, which is helpful. And I think it's one thing to say you've read materials. It's another to have passed a standardized test. And I think we ought to, hold these people to a high standard and expect them to comport themselves in the same way a licensed attorney would in terms of ethical concerns.
I agree. And having been on an interview committee, I can remember one in particular where the person had a question mark by several of the interviewers, and someone, I hate to say it, but someone knew the candidate and sort of lobbied and got the person through the process, and the person passed the bar, and they were a disaster in private practice and ended up surrendering their license, I think, before it was taken from them, but the person no longer practices law. So having that memory of a person with questionable character, I think it's good to show that they've passed it.
Okay.
So I guess the only thing I would just make sure I'm understanding correctly is this would be different than the actual law student, because law student obviously doesn't have to take this.
Right.
So I guess the question is, are we trying to track pretty close to what we're doing with law students, or are we going to step it up a little bit? And I mean, that's just more of a general question. To me, that's kind of stepping it up a little bit, which is fine with me.
Yeah, and it is, because it's one of those things. The law students, like you said, they don't have to have taken the MPRE to be a certified law student. The thought being that they're still in law school. As a law school graduate, presumably the person was required to take professional responsibility. But the MPRE does kind of offer this, first level. I mean, everybody has to take the MPRE if they're going to take the bar exam, or at least be admitted to the bar. And so that's adding it kind of maybe gives folks a bit more comfort that the person is familiar with the rules of professional conduct and their professional responsibility. But it is yet another test. And, would that be something that ultimately gets in the way of somebody's ability to be certified? If they say, well, I'm going to focus on the bar first, and then I'm going to take the MPRE. Say, well, you can't be certified to practice. Do you want that threshold met of successful MPRE passage before you can actually be certified? As Peter and I went back and forth on this one for a bit too, or not sure exactly.
Yeah, I mean, because it really, our focus, our primary guiding star here has to be public protection, and our guiding documents are these rules of professional conduct. And it is certainly justifiable to say that we think that this should be people who are given some ability to practice law outside of law school have at least met that barrier. That's kind of what I was, where I've come down on when we were talking about this. I do think there's a question on whether this entire rule should apply to anyone who graduates, even if potentially they don't ever intend to even take the bar. I know that, for instance, Nevada has in their rule that they have to intend to become a member of the bar. Well, I don't know what they do to prove that, but the way it's written right now, you have to pass the MPRE, but we don't really say you have to ever intend to become licensed.
No.
So,
And there is a limited window there, you know, and that's kind of,
it's limited. We have the limit, the time limit, guarantee there too. But I would feel more comfortable if we had the MPRE requirement. I do think that there's a possibility that keeps somebody from being able to use this option, but the trade-off being the comfort that we know that they've at least hit that floor, I think is a fair trade-off.
And I looked it up too. The MPRE is offered 3 times a year, March, August, and November. So I mean, if we keep our February and July exam, and for some reason they haven't taken it, that's a pretty quick, easy fix.
yes.
That's their only holdup.
Yeah, I'm fine. I'm good with it being in there. Anybody else have any other comments about that? That's fair.
I'll just offer one, and I know I was in law school back when Moses was a baby, but it was unusual for somebody not to have taken the MPRE during the time they were in law school. It's an easy, knock this thing out, then all you need to concentrate on is the bar exam afterward. So I think, Peter, you mentioned the instance is pretty small where people have not completed that and passed it successfully by the time they get their degree.
Yeah. Kevin, you had something to add?
Yeah, it kind of 2 pieces. One, with the pursuant of the licensure, that was one of the recommendations I was going to make on the attesting and writing on that last subsection, is I actually think they should attest that they will be pursuing licensure within the time period that this would cover. In terms of the MPRE, I can see both ways. I don't have an issue with it personally, but I could see, I was a certified law student, so I practiced in Durham in the DA's office. It would have bothered me personally if I've now graduated. I know more than I did before, but I'm not allowed to practice if I haven't taken that test and passed it yet, but I had no issue doing it a week ago. So I could see that argument coming back. But I agree, most of us took the MPRE during law school. So I don't think it's one that's a killer. I'm for having it in place because I think it is something that is necessary as far as the rules of conduct and following them. But I think that's an area that could get some pushback, especially if we're saying it's okay if you fail the bar exam and you can fail it twice and you can still keep this licensure, but we're saying you have to pass this other test as opposed to representing that you've read the rules.
Yeah. Jay?
I agree. I think we ought to include that.
Okay.
Which one, Jay?
I'm sorry, we ought to include that they have to pass and score on the MPRE.
Okay.
Yes.
What do y'all think about including a requirement that they attest their intention to apply to the North Carolina bar?
Yeah, I can see that from what Kevin was saying too. I wouldn't have a problem adding that there, since it's, I mean, if they're wanting to work in the DA's office or public defender's office under these rules, I think we could put that they have to intend to take our bar. I doubt they're going to be wanting to go to Virginia.
Well, and I think it's more for show, because if, let's say they do this and, they decide, hey, we're going to go work in Virginia, we really can't do anything about it other than void them upon, because they're going to leave the DA's off. They're going to leave the Rockingham County DA's off.
Right, they're gone anyway. So
I mean, it's nice to have it in there, but there's no teeth to it.
Well, and I think the intent is there. I mean, I can't imagine a DA's office would want to hire somebody who doesn't intend to become licensed. If at the very least, they are probably at least telling their hiring manager or interviewer that they are, because if this whole point is to be able to keep people on so they don't lose positions, they're not going to want to hire somebody who really doesn't intend to become a licensed lawyer.
I don't think it's necessary. You've got that limited number of times that the person can take the bar. It's already has a window in under which they're required to do something, or the opportunity ceases to exist for them anyway by operational law. So I don't see it as necessary. It's added pressure on the the graduate to say I'm going to do this at my first opportunity. And I think it was mentioned earlier that someone might want to take the first 6 months off just to regroup, and sometimes there are family issues, especially babies that come along, and it just might, just from a psychological advantage, I think, knowing that they don't have to sign that and they're committed. I'm going to get this done within the next 2 attempts. I know if I don't, I'm gone anyway. I know that if I leave this place, the opportunity will cease to exist because it's attached to this particular place or this opportunity or a like opportunity permitted by statute. I think it's already there. It's redundant to me.
Do any of the other 3 states that you identified who have similar provisions, do they have something that kind of codifies the intent of the person to pursue licensure in that state?
So I'm gonna pull up, the only one that I saw that had this had language was Nevada, and it was, I don't think there was any teeth to it at all. I believe it just says, it must be accompanied by a statement, let's see, written certification, just all it says is have, the only line is intend to become a member of the Nevada bar. But there's no, it's still, it doesn't terminate if they don't apply for the bar or if they don't apply for the test. It just still just terminates in 12 months if they leave employment or they're admitted. So I agree with you, Judge Hennett. I don't know that there's really without any teeth or anything, it's really just symbolic, and I don't know that it's necessary. I would imagine anyone who is using this is using this because they want to become a lawyer and want to keep this job that they have. And without any real teeth behind it, I don't know that it's necessary to have it in there, but I think the spirit, as Kevin is saying, the spirit is hopefully that we want people to be using this to get that second or third chance and have a job while they're doing it, not to say, I don't ever really want to be a lawyer, but I've got this job that they offered me and I'm going to do this until it runs out. Like, I can't imagine that will happen. And I know it's not the spirit of what we intend. And so, and without how would we ever say, well, you didn't really intend to do this, so now what you said to us was a lie? Like, how are we going to ever prove any of that? So,
And intent can change. It could be one thing that you see in front of you on your date of graduation, and as Judge Hennett said, circumstances can change.
Yeah.
And I agree with that, but I guess where I'm coming from is right now I come out of law school, I fully intend to proceed with everything, but I want to take the second bar exam or maybe the third. If I'm not registered for the third bar exam in a timely fashion that I can take it, I don't think I should benefit from continuing to practice until the results of that third exam. If I have nothing in place that will allow me, there's no chance of me being an attorney when those results come out, because I never registered for any of the 3 bar exams. And I think there's teeth later where it does say, just like with the law students, a judge can come in and say, you should revoke this. The supervisor could come off of it. Maybe part of it's aspirational language, but I think that's a concern I would have is if we don't have anything laying something out. I always look at things in terms of how somebody can abuse it. I know we're trying to help, but that would be that concern.
Any other thoughts on whether we should add that language right there at the end of, I guess it would be number sub 6?
I'm going to lean towards adding it only because of, the protection of North Carolina residents, and that may help, if we get into legislative aspect, Peter maybe asks his legislative liaison, how are the rules coming? And if we leave it in there, that may help grease the wheels a little bit on the legislative side of it, or if we have any questions. And I would tend to leave it in there. And if something changes, something changes. I think that's going to be a rarity.
And Brian and I will look at whether like the attestation part is the right spot, or maybe it's something you put in the definition of the certified law school graduate,
Right. Right.
that's their graduate is certified to do this, graduate with the intent to become a licensed lawyer in North Carolina. It could be a definitional thing that's not necessarily something they have to attest to. We can play around with this idea and bring it back to you to
No,
take a look at.
It makes sense to put it in the definition, and then it catches both the attestation and the period of time that they would have to pass the bar.
Well, let's look at that.
That's good.
Let's look at it from a standpoint of either putting it in here, putting it in the definition, one of those two, and we'll get that settled out at the next meeting, which is in a couple of weeks. We should be able to knock that out and give us all a chance to kind of think about that a little bit.
Right. All right, let me move on in the rule then. We're talking about form and duration. This is something where we did make a change to the student section when we made this, set out what it looks like for a graduate. And this is currently the student certification lasts for 18 months or until the announcements of the results of that first bar exam after graduation. We've changed this to just simply say until the announcements of the results of the third bar exam following the certified law student's graduation. So that effectively gives somebody, you call it 15 or 16 months after graduation, that they can engage in this supervised limited practice. And we did that because, the first law school exam, I mean, clearly that's the limitation right there. It's not helpful, but pushing just to the second just doesn't feel long enough. Doesn't feel like you would have that capability, especially if somebody fails the bar exam in July or get the results in August, and they simply don't have the ability to actually take that February bar exam. They're planning to take the following July. So we thought that would be a reasonable time frame there. And like I said, we changed it not just for graduates, but for students as well. I don't see this as really being something that, where some student can get certified first semester of their second year, and they basically have that same certification for the next 3 years. Students are often in internships or externships. They're limited in duration. And of course, certification terminates when we either hit that time period or when the supervising attorney withdraws as the supervising attorney. So, in that unique scenario where somebody gets hired on as a second year law student interning at a public defender's office or district attorney's office, I guess it would be possible that same certification would last until the third bar exam results were released after graduation. I think that's pretty rare, and even if that's the case, that's I guess I don't really have a lot of heartburn over that.
Yeah, I don't have any issue with that. When I read it, it sounded fair.
So in interest of keeping honoring everyone's time, I know that there are a couple things that we were hoping to get some advice on or your thoughts on. So when we can bring this back to you, particularly this highlighted one that we have here that Brian's sharing, which was read, approve, and personally sign any pleadings or other papers prepared by the certified law student or certified law school graduate prior to filing, and approve any documents prepared for execution by a client or third party prior to execution. That's the rule right now for law students. We'll say that, like, in looking at some of these other states, there's at least one of them kind of gives the ability for the graduate to, over time, in the opinion of the supervising attorney, to have more and more independence. But that it's still, whether or not they're signing something, that still puts the onus on that supervising attorney to have reviewed and approved those things. Whether or not they have to put their signature on it, I think, is not as uniform from all of these different states.
And this question came up just as much from just thinking through the practicalities. Somebody working in the DA's office, they get assigned to, traffic court or whatever, and there's a lot of little things that they have to sign. Do they need another attorney there to sign off on everything that they approve? Is that actually adding to efficiency, or is that causing more of a problem? But at the same time, these certified law graduates are not yet lawyers. You just have to recognize that. And there's, as much as the supervising attorney is going to be on the hook for any sort of potential errors there, does it take that step, that extra step that's needed to protect the public, to ensure that the licensed lawyer that's supervising this law school graduate actually puts their eyes on and approves everything that actually gets signed?
Yeah, if we're looking at protection of the public, then by all means.
No.
Anybody else comment on that, or strong thoughts one way or the other?
I agree. I think I think we ought to keep that.
Yeah.
I don't know many DAs that let many of their assistants sign anything without them looking at it, much less than somebody who's not a lawyer.
Right.
So I think
I agree.
I agree.
I did notice there was a qualifier, at least in subparagraph 2, where the phrase reasoned discretion was used. And there's some other places, that dealt with a faculty member. There's some other places where the supervising attorney doesn't have that kind of qualifier. I just wonder whether that ought to be repeated in a couple of other places here or not, or maybe the reasonableness standard. I don't know, but it just is one of those things that looked inconsistent to me.
Mm.
Yeah, subparagraph 2 is one that I think, we didn't even change this rule here, but it's not my favorite rule. It essentially says you shouldn't supervise more than 2, except that you can in your discretion. And it's like, that seems like a waste of language here that we put in here. But some of these other states kind of give that discretion of the supervising attorney in communication, also with the court, with judges or anything, to give more independence to the supervised graduate as they see that it's they are capable of doing it. One state has has minimums, like you have to have supervised them doing one of these kinds of cases, and then actively supervised, and then watch them do another case before you then say they should be allowed to do something on their own. I mean, there's some more details and specifics that some states get into, and we'll look at all of those too to see if there's any value in it before we bring it back to you. And
real quick, that was I was chair of that committee. That was a compromise with a bunch of law school academics, and that was the only language we could come up with to get it rolled through. So,
Right.
and I know this is being taped, but yeah, that was compromise language to get it done.
All right. Way to get the W, Matt.
So going through the rest of this, then of course there's filing requirements that are pretty standard, and this was a change just in terms of overall tone. It was a focus previously on the student, and really it's kind of focusing on, well, the supervising attorney has to provide that signed statement, things of that nature. Moving on through all this, I'm not trying to just give short shrift to it, but I think these kind of just stand for themselves. We've already highlighted the ones that we wanted to hear your feedback on, for at least that were more urgent to us. Everything else is basically just kind of facilitating this process. So so we had this this section in activities. Some of this language and activities, I think my comment here in this this second paragraph was, even if that was necessary, it was kind of a mirrored comment from another part of the rules, but
It seemed to muddy it a bit.
Yeah.
It seems unnecessary in some way.
I don't disagree. And then everything else you can see, we're just trying to add in certified law school graduate and things of that nature. So we had use of the student's name, which, or the student, now it's just use of name, but it's going to be mirroring the same sort of thing. Graduate and student names are basically going to be treated similarly. We eliminated this student practice placement because, quite frankly, I don't understand how this really plays in. As we were looking through this, this is all about a supervised attorney or supervising attorney and the student. That relationship, clinic issues are dealt with in a separate part. The student practice placement just felt very redundant. So reading through, we just kind of felt like, I don't think we need this. And that was the end of the changes. These other ones really dealt with more student issues because they're doing law school clinics as well as pro bono projects through private firms. So that's the proposal. Like Peter said, we're running up at 1:57, want to be respectful of your time. I don't know if anybody had anything else that they wanted to bring to our attention as you looked through it. We certainly have some changes that we can make, and we can send out another draft. We have something scheduled for 2 weeks from now.
And I know, Greg, we had talked about, I think the agenda talked about bringing in some other entities who might be interested in this to the next meeting, with the hope that we can have buy-in before we put the rule through the publication process. So, if we're on a time limit, time crunch to get this passed. One, I know Kevin had mentioned a public defender, and I think that would be really helpful because I do think it's worth having a discussion of whether this implicates any kind of issues constitutionally on what a law school graduate could do for somebody who has an appointed counsel or a public defender. So we would might want to have that conversation in 2 weeks. In addition to bringing in maybe a law school reps or a public defender and maybe legal aid as well.
DAs or something like that.
Yeah, I think that would be great. And so Kevin, I was all for getting that opinion. I just wanted to make sure we got through this first kind of reading first so that we were all on the same page. I do think the input that your public defender could give would be awesome. I plan to talk to Ms. Cook here, Brandy Cook, our DA, kind of go through that with her as well. I'm all for inviting some, obviously we're going to be on an hour, so I don't want, we got to limit certain things, but I would like to hear their input.
That would be helpful when, as an assistant public defender, the clients often say, "Are you really a lawyer? Are you a real lawyer?" So there might be something extra that we need to do there for criminal defense work.
Yep.
I'll offer one other thing, and Peter and Brian, I'd like to discuss with you the duration paragraphs that are on pages 4 and 5, but on page 8, there is a phrase, law firm, that's used a couple of times in what probably should be subparagraph B. There are 2 subparagraph A's there. I just wonder whether that's confusing if these folks aren't going to be in a law firm setting.
We will make sure to clean that kind of stuff up before we bring it back to you.
Okay. And the 2 subparagraph A's, that was this additional, we're gonna delete that second subparagraph A because that was the paragraph that just muddies stuff.
Okay.
And so we'll get rid of that, but I'll look through to make sure that the phrase or references to law firms is.
Yeah, page 8 was swampy.
Yeah. A lot of these rules felt swampy. What were you thinking with regards to the duration, Craig?
Just, is there a possibility that somebody kind of comes out of the supervision after the bar exam results are announced, but before they get sworn in, and we need to deal with that set of circumstances? It's nuanced, but we can, it's probably something that doesn't merit everybody's time right now.
Yeah.
I'll talk
Well,
to you
there
about
there
that.
is a provision in there in duration of if the certified graduate passes the bar, certification remains in effect until they're sworn in by a court, similar to a student, or the student section as well.
It
So
says results of the bar exam
Yeah.
as opposed to the actual swearing in. Is that what you're referring to?
I'm
I think there's
referring
Greg,
to,
differentiating between
Separate
the two?
paragraph, right? Yeah.
But there's that proviso at the end about the supervision and filing requirements are at all times satisfied. So that's the issue.
I see exactly what you're saying. I
Yeah.
see what you're saying. Yeah,
Okay.
that they're all time satisfied. Yeah, we probably need to address.
Just take a look at that. And
Yep.
I don't need to call you. You already figured it out.
Got it.
Yeah. Any other discussion about the first reading? And secondly, is everyone okay with input from outside of this committee, such as Kevin's contact with the public defender there, and maybe if anybody else has any ideas, shoot that to me, Brian, or Peter, so that we can kind of include them. Anybody have any strong opinions against that?
No, I think it's good.
Okay. So we're a couple minutes past the hour. Judge texted me, I'm good for a little bit, but if there's any other discussions, we can handle it now, or we can, if need be, we can adjourn at this point and know we have another meeting coming up in, looks like April 10th, I believe.
Yes, it's April 10th at 1 o'clock by Zoom. So Peter and I will make some adjustments based upon our conversation today and send out a new revised copy of these rules. And we'll also reach out to some interested parties, namely folks like district attorneys, public defenders, and some of the law school representatives to see if they wanted to participate and weigh in. But it'd be
And if there's other
lovely.
areas that you want us to address or that you have questions about, just shoot us an email so we can be prepared to address those at the next meeting.
Yeah, and just so everybody's on the same page, what we're really looking to do is at the April meetings coming up, hopefully have a proposal on the board for the issues committee to move forward with. So this might be a pretty quick subcommittee is what we're hoping for. At least that's what Matt was hoping for.
Yeah, I mean, this, like Peter said, the goal is if we get it approved in April, we publish it, and hopefully not a lot of adverse comment, then it's back in front of us in July for approval by council, and then we're sending it off to the Supreme. So in theory, it depends on how quick the Supremes act, but in theory, we've done our job to get it to folks who are going to find out about the July bar exam at the end of August, beginning of September.
Right.
All right. Anybody have anything else? Well, I just thank y'all for your time. This was very insightful. I think the discussions were really good. So we'll look forward to seeing everybody in a couple weeks on the 10th at the same time.
Yep.
And if you have anything further, email us about it.